Okay, good afternoon, everyone. All right, I know that I am not quite standing between you and cocktails because I know that there's a closing keynote, so just want to remind you that you still have one more barrier before cocktails, so and I'm not it. So, oh, two, okay. Oh, fabulous. All right. Well, with that as a backdrop, I want to welcome you to Privacy Impact Assessments Insights from the GDPR. I'm Scott Giordano. I am a VP at Spirion, and I specialize in data privacy and security law. So if you have legal questions, you can feel free to grab me afterwards. I will be happy to give you an legal analysis, but not a legal opinion. And I came to Spirion kind of in an interesting way. About 4 or so years ago, I worked for a defense contractor in Seattle that is not Boeing. And in doing so, we needed to go and find unclassified data, what's called CUI, Controlled Unclassified Information. You've all probably heard of it. And so that's how I came to wind up meeting Spirion. Fast forward, I went to a consulting firm thereafter and spent about 2 years doing implementations on, you guessed it, GDPR. So learned a lot about privacy impact assessments under GDPR. I'm going to share with you what I've learned and how they might apply to PIAs that you all might do. So that's what we're going to do. If you leave with nothing else, I want you to leave with 3 things. One of which is that the nature of personal data has expanded greatly over the past decade, and so have the opportunities for misuse and abuse and loss and things of that nature. Secondly, the Europeans have introduced this idea of rights and freedoms that are potentially violated through loss of personal information. And so we're going to talk about this idea of rights and freedoms and how I think that there's an opportunity to shed some light on how PIAs could be conducted using the same standards. And then finally, we'll talk about doing a DPIA, a data protection impact assessment, and how that can offer a second opinion for your own PIAs. And I think there's a lot of value in that, and we'll walk through an actual PIA or DPIA that I've done. So you'll have a live one that I've redacted to protect the innocent. But I think you'll enjoy that immensely. And so if you have questions, feel free to raise them as I go through this. I want to make sure everyone gets their questions answered. And also, please do fill out the survey at the very end of this. I'd be very grateful in getting your feedback. So without further ado, let's talk about why we're here today. One is that the nature of personal data has changed substantially over the past 10, 11 years. And I use 2007 as a marker for that. You can see here that OMB, Office of Management and Budget, the privacy police, if you will, for the federal government, issued a memo back then describing the nature of PII. And so it talks about ideas like name, social security number, biometric records, things that are linkable like a date and place of birth, mother's maiden name. These are things that are all old news to all of us. We've all heard about these ideas. And so what's interesting is that OMB updated this just last year. And in doing so, they added things like identity documents. They added precise location information, places of employment, medical history. So they've expanded the scope of this in the revision they did to the data breach notification procedures that they published last year. So that's expanded quite a bit, but wait, there's more. You're all probably familiar with California Information Practices Act because this is something that applies to California agencies, and it talks about items like physical description, education, employment history, statements about or made by someone. So you can see how the edge is being pressed greater and greater as to what qualifies as personal information. And so when the GDPR came online, it expanded that yet again. So Article 4 of GDPR talks about information that can be used directly or indirectly. And so it talks about identification numbers, location data, online identifiers, and we'll talk about that more in just a couple minutes. Also, something that's really fascinating here, the idea of one or more factors specific to a physical, physiological, genetic, mental, economic, cultural, or social identity completely expanding, again, the edges of what qualifies as personal data. And you may ask, gee, Scott, what are all these things? The answer is, it's a good question. I think in many cases, a social identity is fairly easy. It's your social identity on a Facebook or a LinkedIn or something of that nature. But you can see there's other identities, like a cultural identity, for example, and that is something that leaves a lot of opportunity to expand upon as time goes on. There's also this idea of an online identifier I just mentioned, and they talk about online identifiers in the GDPR as things produced by devices, applications, tools, and protocols. And you're probably saying at this point, gee, Scott, that could be just about anything. And you're right, it is just about anything. And this is something that gave my clients, quite frankly, gave them fits when I did DPIAs for them or did assessments for them, because just about anything now qualifies as personal information. And this is something that organizations had 2 years to prepare for, because the GDPR came online, as probably many of you know, in May of this year, and 2 Mays ago is when it went into effect. But you would be amazed at how many organizations really didn't take the time to understand the nature of personal data into about 30 days before the law went into effect, and my phone was ringing off the hook. So under the California Consumer Privacy Act of 2018, by the way, how many have heard of CCPA? Can I see some hands here? And I won't bug you with too many polls here. Okay, thank you. This is really pushing the edge of the envelope here, and you may say, well, how so? Well, it's information that identifies, relates, describes, either directly or indirectly, so we've heard that before, a consumer or a household. So now I've added household. So imagine that potentially you are a private utility, electric utility, for example. You're a government-sponsored organization, and so you're subject to this. And now households are subject. So we've expanded the privacy definition again. But wait, there's more. There's 10 different categories of personal data. So we have things that you might expect. Online identifiers, like we just discussed, personal identifiers. We have information about physical characteristics. We have your education and your employment history. So those are things that you would expect by now are probably personal data. We have information about protected classifications, meaning protected classes, race, ethnicity, religion, and so forth. Transactions of personal property, so your viewing habits on Amazon or eBay. Those are great examples. Your histories of purchasing, or just looking at things. Perhaps you've created a wish list or a registry or some kind of other list. That's all now subject to this. Interacting with an advertisement, clicking on an advertisement, that's now protected. My second favorite, olfactory information. So I guess depending on how you smell, that could be personal information. So it's just amazing what the government has decided qualifies as personal information. And of course, number K, item K, inference is drawn. This has really expanded the nature of personal data, because in the GDPR and other statutes, it was implicit that there was some inferences that you could make about personal data, and they were protected. Here, this comes out and just flat out says, inferences about personal data is protected data. At this point, you're probably asking, is there any limit to what qualifies as personal data? And the answer is likely no. And I realize that CCPA does not apply to government agencies. My reply is not yet, okay? And let's look at one more thing before we change gears here. NARA, you're probably familiar with NARA and their CUI registry. And you probably are familiar with it because, in principle, any information the federal government gives you, a state or local agency, is potentially subject and should be subject to NARA's CUI registry. In this case, I've pulled out the section on personal data, on private data. So data that winds up in contracts or in death records, general privacy, genetic and health information, so things that you would expect would be personal data is now considered controlled unclassified information, which raises the level of protections that are necessary per NIST 800-171. If you haven't had the joy of going over NIST 800-171, I highly recommend it. It's quite involved, and this is something that defense contractors had to address last year. It's something likely that all agencies will start having to address in the coming years. You can see under the General Privacy tab that the marking, PRVCY, this is something now in principle, and I emphasize in principle, federal government agencies have to mark when they give you personal data that was just described earlier. And this is per OMB M1712, 17 as in 2017, so it came out last year. So in principle, the federal government is going to essentially push this onto you, the responsibilities to protect data per the CUI registry and NARA's requirements, and of course NIST Internet 171. So if you have not seen this, I suspect you shall in the coming year or coming years. So with that as a backdrop, why PIAs and DPIAs then? And I know many of you probably have already participated in PIAs, but I want to give you a different perspective here. So a little personal data goes a long way. 95% of Americans can be located or can be identified by just 4 time, date, location points. So just 4 of those can identify 95% of Americans. 2013, someone was able to take the Kinsey study from the 20s and 30s on human sexuality and de-anonymize the participants. And this is especially chilling, folks, the idea that you could participate in an anonymous study and then someday a technology exists that can essentially uncover you. Now, admittedly, this was a long time ago, but the principle still remains. And then in more recent vintage, you had Netflix, who did a project for recommendations. 500,000 people participated. And as it turns out, researchers were able to de-anonymize those folks down the road. And this is all from Bruce Schneer's book on data and Goliath. Is anyone a Bruce Schneer fan, by the way? I won't do too many polls. If you haven't read Bruce Schneer's books, they're excellent. I've been reading his stuff for 20 years now. He is truly exceptional on information security and privacy. So this is why we have DPIs and PIAs. And if you take the perspective from the Europeans, they have this idea, one of processing personal information, and for them, processing can be anything. Looking at data can be processing, deleting it is processing, moving it is processing. So anything you do to data is processing. So it's a very wide definition. And then they introduce this idea of high risk to rights and freedoms on natural persons. So you might ask, great Scott, what are rights and freedoms of natural persons? This is something that we really don't talk about here in the US vis-a-vis personal data. And so the Europeans talk about this in terms of freedom of speech, of conscience, of religion, of thought, things of this nature. And this is a completely different way, in my view, of looking at personal data and looking at what happens when personal data is lost or it's misused or abused. We're all familiar with all of the charges of misuse of personal data that went on with the election in 2016, and I certainly won't reprise those now, but the idea is that this is something that's now coming to the fore, and it's being brought to us by the Europeans. And so it's a fascinating idea, and we're going to dig a little deeper into it. In terms of the high-risk piece of this, there's not a definition of what qualifies as high risk, but what we have here is this idea of really 2 things. One is either you're doing an automated identification or evaluation of someone. And things we take for granted here, like if I want to get instant credit, I mean, you've all seen instant credit. Essentially, you call up a retailer and say, I'd like instant credit. Well, they're going to go to a credit reporting agency and make an automated decision about whether or not you get credit based on a profile that's in your credit report. This is exactly what we're talking about here. So things that we take for granted here in the US are essentially prohibited or are very suspect in the EU. Then there's also this idea of large-scale processing, and the idea that if you process enough data, then at some point it becomes high risk. And so in that respect, quantity has a quality all its own. So if we dig a little deeper here, we find that you've got 2 species of high risk. You have things that produce legal effects and things that produce significant effects. So legal effects. Say that you have a loss of personal data and you lose a social benefit, okay? Or you can't come into the US anymore, or you have increased security measures. And we've all heard stories in the news about things of these happening here in the US. Here they've been identified by the EU, and I've emphasized the last one here, prevents exercise of rights under a contract or a service. And you may ask, what is that, Scott? It can be just about anything. And so, for example, when I was working for my defense contractor, one of the issues we had with personal data is that you couldn't dig too deeply into someone's background when you're looking to hire them, because that would prevent them from the benefit of an employment contract. So you can see that this becomes something that can be a catch-all for just about anything, and it's very easy to run afoul of the laws in the EU as a consequence. In terms of significant effects, you have things that are very large scale. They address someone's health, they address economic status, they address changes in ways that forces people to change their behavior. So they're very subtle things that, again, we probably haven't done a lot of deep thought at here in the US. This is something that they've thought of in the EU, and I think it sheds a great light on how to look at personal data. I'm going to do a full stop there because I know I've gone through a lot of material in a short time. Are there any questions or comments or anything that anyone would like to ask? No? Okay. More high risk. So large-scale processing, so things like processing at a hospital, or if you have an insurance company processing data, or my favorite, telephone or internet service provider processing. That's something that we all use probably most of the day, every day in some form or fashion. That's all high-risk processing now as far as the EU is concerned because of the scale. Now let's compare that to the PIA here that we would use in the US, at least at a federal government level. And so e-Government Act, you're probably all familiar with the e-Government Act. It was a watershed moment in US technology history, certainly as far as the legal system was concerned. It established quite a bit of new law here in the US. And one of this was a PIA, which had been done informally in other forms previously, but now it really brought the PIA onto its own. And so the whole idea here of a PIA was to conform to legal requirements, to make sure that you understood the risks and effects of what you were doing, and to mitigate risks. So that's all great. But if you dig into PIAs a little more, you'll find that the government really had only two scenarios. One was either you're buying new technology or you're collecting new information. And that's it. Those were the two big buckets of scenarios. And then within those buckets, you had some subtlety. So you could have a case where you're de-anonymizing data, or you're doing new uses for existing technology or new uses for existing personal data. And most of these changes all address things like changing systems, or new use for a system, or new use for a technology, or for personal data itself. So you can see here that they tend to skew towards one or the other. The subtleties that we just saw in the previous slides here that the Europeans use, really we don't see here. And it's not that I'm saying that what we're doing here is bad, it's just that the European view, if you will, offers a lot more of a deeper look into secondary effects that might happen if personal data is misused. This is called a threshold analysis. This is something I used constantly when I was doing assessments. And it's the idea that if any two of these 9 criteria are present, then a risk assessment, or if you will, a PIA or DPIA, is mandated. And it's something that you have to make available, you as a company have to make available to the authorities in any of the 28 EU member nations. So for example, if something goes wrong with a system that's considered high risk and you didn't do a DPIA, then you are going to run afoul of the GDPR, which all of you have likely heard of, and the idea that you could have up to 4% of your annual revenue as a fine, or 20 million euros, whichever is higher. So it was a very scary prospect for my clients as a consequence. And so we went through this threshold analysis, and you can see all kinds of different criteria that are much subtler. The idea, again, of evaluation or scoring, like we talked about earlier, automated decision making, we also discussed that, but other things here. Again, number 9, prevents a right or using a service or a contract. So you can see that these kind of criteria, again, really transcend how we do things here, but they really inform the DPIs that I did, and I could ask these questions, and almost certainly I would hit on 1 at a minimum, and likely 2, just because of the nature of how personal data is processed nowadays and has been for some time. If you contrast that with the US version, this is DHS, Department of Homeland Security, there is, I don't want to use the word superficial, but it just lacks the kind of subtlety that the previous one we just saw did. So you can see here from whom are you pulling the data? Employees, contractors, or the public? What information, such as SSNs, are being incorporated? Do you have a particular medium, like mobile apps, webs, SharePoint, etc.? And are you sharing it within or without DHS? And it's not that these are bad, it's just that you could see previously the European perspective on this really went several levels deeper and described what kind of subtle or secondary effects might happen as a consequence. And so this really represents, I think, a big contrast between the two approaches to PIAs, and I think the DPIA version really offers a lot of insight that we just previously perhaps haven't thought of. Again, I'm going to pause there before I dig into an actual DPIA that I've done, but I want to, again, give an opportunity for questions or comments or anything. No? Oh, yes, sir.
For OMB, did they take a lot of those lessons learned from what happened to them?
Yes. You're going to find that especially the hack that happened for the Veterans Administration, that had a huge cascading effect on everything else. It really did. And I'm sure you're all familiar with the hack that happened some time ago at the VA, where basically every record they ever had was compromised. Now, supposedly that laptop was never truly compromised. It was lost and it was recovered, and bad guys didn't really get the data. But the problem with that is that it should never happen in the first place. And so, I mean, that concentration of personal data in such a small place is just, it would have never passed a true PIA, because you would have looked at that and said, there's no way you would put all your eggs in that one basket. And so the net of it is that a lot of the information you're seeing here came out of that VA hack. Other questions, other comments? Yeah, yes?
So I know NIST 853 went forward through the privacy.
Yes, it does.
And how do they compare with GDPR?
Here's what's interesting is that GDPR doesn't prescribe any controls at all. Conversely, there are some controls it's in love with, and I use that somewhat tongue-in-cheek. They love something called pseudonymization, okay? Meaning tokenization. We would call it tokenization here in the US. They call it pseudonymization. They mention it about 20 times in the GDPR that they love pseudonymization. I don't know why, but they've gotten fixated on it. They also mention encryption throughout, which you can expect, especially if you're in a cloud environment. Encryption is probably your best bet. So the net of it is they don't talk a lot about it, and they don't specifically because they leave it up to us to decide which standards we want to use. Now, I heard rumors that they were going to recommend NIST 800-171 because it was a medium level impact per FIPS 199, but it was something that was achievable over time without a disproportionate amount of effort. That's the rumors I heard. I've never had them confirmed, but it wouldn't surprise me because 800-171 was a pretty good piece of work. It was a nice balance between not doing too much and not doing too little. And so the net of it is that whenever there is a breach, and there's been a lot of breaches reported, there's probably been several thousand reported since the end of May in the EU. So when those are resolved, I'm very curious to see the publication of whether the controls that were in place were adequate, and if they were, then how does that impact what kind of fine, if any, that you get? Because in principle, if you've done all the things you can do reasonably, you shouldn't get a fine at all. That's the European view, I think. I don't think I'm speaking out of school when I say that. But they're not very big on telling you what exactly to do. They presume that we're all smart enough to pick a framework, whether it's an ISO framework or it's a NIST or it's some best practices or it's COPA or whatever your favorite framework is. Their view is pick one and execute it well rather than our trying to tell you what to do. Yes? They don't make any distinction between PHI and any other kind of data. In the EU view, and this is an interesting view, they don't take a sectoral approach where you have financial data, you have medical data, you have educational data. All that goes out the window in the EU view. You only have two kinds of data: regular and sensitive data. And sensitive data is different than what we'd expect. Sensitive data isn't just medical data. It's things about race, ethnicity, religion. Trade union membership is considered sensitive data. This is all outgrowths of what happened last century in the EU. So as a consequence, you have a certain set of data that's considered special, and you have to get explicit permission to do anything with it. So the net of it is that they don't make any distinctions among industries. Everyone has to comply with the same standard, including governments. That's what's interesting. Take a counterexample. CCPA right now is just for businesses. Agencies have their own, I just cited earlier, their own privacy statute and their own security statutes. I think that approach really is not tenable, and that over time you'll see them converge, and corporations and government entities will be held to the same standards, and I think that's probably an easier way to do things. Yes, sir. Mm-hmm. If I understand the question rightly, are other states going to take California as an example and go meet that standard? Is that the question?
Or even if in California, like there's been a lot of people here that like state that local.
Okay.
So do you think like it's going to impact process?
Boy, it's a great question because right now, and I emphasize right now, government agencies are exempt from CCPA, but what I think you're going to see is cultural change that's going to wind up spilling over to state and local governments, or the state government and local governments here in California as a consequence, just because people are going to come to expect that their personal data is going to have that higher level of protection. And I'll give you a great example is that I have a lot of clients, or had a lot of clients in my previous job that were US-based companies with operations in the EU, and they decided just to do GDPR standards for everything and not have a US standard and a GDPR standard. And I think you're going to see the same thing here in California is over time, state's going to say we're not going to have a state standard and then a corporate standard for protecting personal data. It's just all going to be one, and we'll adopt the CCPA standard. And I'm actually surprised. Originally, CCPA was supposed to be an initiative petition. It was pulled to the last minute by the proprietors in exchange for the government passing the law immediately, which is like, I think, probably broke all records. So as a consequence, I think that if they had to do it over again, they would have included government agencies. That's my view on it. They're great questions. Other questions? No? Okay. Let's dive into a DPI that I've done, and you can feel free to ask questions about this as well. So two things. One, just do a DPIA, review your data inventory, presuming that you have one. If you don't have a data inventory, then I recommend that you build one, and I'll show you a sample one in just a moment. This is typically done with interviews. You'll interview the business owner, the technical owner, what have you, someone who's an expert with the system in question. And typically, for my clients anyhow, you had any between 60 and 100 systems that processed personal information. So that's a lot. It's a big project. And then validate that with some kind of a technology will allow you to crawl the network and see, is this data really there? Where else is it? That's the idea behind data discovery, for example. So I'll give you some examples here. This is a sample data inventory that I really did. I changed the names to protect the innocent. The actual document I pulled this from had about 80 or so entries. I've only pulled 2 out of here. And you can see that one system was an MDM system, right there. Other one was a DLP system. I just gave them generic names. And it gives you the, actually I put this in, the description of what an MDM system does. And so this is for the benefit of someone who's not a technology expert. If they're, for example, an attorney who has to review that. Or you can see the DLP system description below that there. And then to the left, you can see where it says, or at least I take that back, it'll be my right. You can see where it says it's for employees. And then it gives the actual data elements. In this case, it gives the IMSI number, the IMEI number, device ID, and ESN. So these are all individual data elements that presumably you'd want to hunt for in your network to make sure you know where they're all located. And then same thing for the one below it, the entry below it. It's your AD credentials, equipment identifier, and so forth. The document that I drew this from has probably another 20 fields to the right of this. I just pulled these just by way of example, but the other fields talk about the legalities involved. What's the legal basis for having this data in the first place? Has this been reviewed by counsel, etc.? So the idea is that if there is ever a data breach, you're going to be able to look at this and go, okay, I know where everything is. I know where the servers this data is on. I know who to call in an emergency. Everything. It's all in one place. That's the idea of a data inventory. And then you do the actual DPIA deep dive. So here you've got part 1, and we just talk about the basics of the name of the system and what's it called and all those fun things. If you move past that, though, this is where it really gets interesting. Here we have the nature of the inquiry. So why are we doing this? Why a DPIA? And we have all kinds of options here. We've got changes to the nature of the data, change in the risk profile, organization context have changed. I mean, so any kind of change that merits a look at the personal data, how it's being used, are all checked here. And so you can see there's some here, like the last one, a system not built with privacy by design or default in mind. Privacy by design is this concept, and I know you've probably all done security by design where you have something fail to a safe state if it fails at all. Same idea for privacy. If there is a breach, you minimize the amount of data that a bad guy can get and can exploit. So these are all some good examples of why you would do a PIA or DPIA in my case. And then here, I know this is a bit of an eye chart here, but you can see examples of the kind of information that you would look for and say, okay, do you have any of these things? And are you collecting it? Are you using it? Are you sharing it internally or externally with the organization? Externally opens up a whole other can of worms because of the nature of having to have contracts with every organization that has this data. And then here is that what's called Article 9 data. This is the data I mentioned earlier about race, ethnicity, religion, trade union membership, sexual preferences, etc. This is special data in the EU. This is something that you have to have explicit permission to use, otherwise it's prohibited. Here we talk about the location of all the servers. Where are all the servers around the world? This may not be necessarily applicable to you yet, but the idea that if you're replicating servers in another state, it certainly would be. Here, this is for in another country. And so as a good example, the more replication, the more hands that touches it, your data, the more likely is that you're going to have a problem down the road. This is documentation in scope that's been reviewed. And so this is all the documentation surrounding the project or the process. So the project plan, the architecture, the requirements list, all the kind of documents that you want to review ahead of time and make sure they're informing the nature of the PIA and whether you should have had one in the first place and where you should look for problems. So these are all important documents to have. And this is something that I would always ask for from a client. 9 times out of 10 they didn't have them, which meant that the project was probably in trouble already. Here we talk about the integrations with other applications. Integrations are a great opportunity to lose data or lose track of data. I know for HR systems, for example, whenever I work with clients, a lot of times they said, oh yeah, we've only got 10 integrations with Oracle or whatever HR system they were using. And typically we found for every application they knew about, we found 2 more they didn't know about. So integrations that went into all kinds of other systems they didn't realize until we tested it, we validated it with data discovery. And then you can see also towards the bottom, data classification. The idea that we're classifying data in a certain way, in an automated way, so that our DLP system can go and catch it if it tries to escape the network, or at least put restrictions on it. Part 2, again, is something that you probably wouldn't see necessarily in a US PIA, this idea of what's the legal basis for processing the data in the first place. And so we have things like the consent of the person in question, or there is a public interest in some cases, or there is a vital interest, there's an emergency, but there has to be at least one legal basis for processing personal data in the EU, otherwise you can't do it at all, full stop. There also has to be a legal basis for moving the data out of the 4 walls of the EU, so another discussion entirely. And then there's this idea of proportionality. Are you collecting only what you need, or are you collecting too much? My experience has been here in the US, historically, we collect way more data than we possibly could use because there's the idea that we may want to do something with it down the road. And so we create this junkyard full of data, and then if a bad guy gets their hands on it, then they're exploiting all kinds of things. So this turns it on its head and says, do you really need all of that data? And as a consequence, a lot of times my clients will say, no, we really shouldn't be collecting that. We just did it because everyone else was doing it. Subject rights, okay, have the data subjects, that is to say the consumers, in our case, or citizens or residents, been informed about their rights under the law and what's happening with their data? Is there some kind of transparency? Have they been apprised of the risks involved? Does the organization, the corporation in this case, are they apprised of the risks that are involved as well, and have they transmitted those risks to, or notified those risks to the individuals? So this is something that I think is very powerful, and I'll give you some examples of some feared events and what happens. Someone could be at risk for identity theft or discrimination in some form, or loss of freedom of speech or thought or conscience or what have you. So you can see that this list is really a nice laundry list of potential bad outcomes, and I think it's a great model for using for US PIAs because you're really looking down at very subtle effects and saying, what could a loss of this personal data do to these people? Here this says, well, what might an individual, we call them data subjects in the EU, what might an individual not be able to do if they have their data absconded with or misused or abused? They may not be able to exercise their legal rights. They may not be able to get access to the data at all. It may be destroyed. And so this is a great outcome, if you will, or a great potential outcome to look at and go, okay, if something bad happens, what happens to the individual? So it's a great exercise. It really forces us to think through things. I know this is a bit of an eye chart here, but this is the risk mitigation. So what kind of risk mitigation are you doing? We talked earlier about controls in place. Here we've put some just very basic controls. Data's been encrypted, it's been anonymized, it's been pseudonymized. Okay. It's had other measures put in place, but you can see there's a whole laundry list of information here of boxes you can check and say, yes, we've done all these, we've done some of these things. So that way you can always look back later and say, okay, probably we weren't thinking this through, we probably should have added a few more controls, but here at least you're documenting what you did. And then the most important part of this entire document is a sign-off by the CISO and legal authority. That way, if something goes wrong, it lands on both of them. If there was a data protection officer, which is mandated in some cases in the EU, then the DPO is also going to take the hit as well. And this is something that usually brought DPIAs to a screeching halt, because suddenly then it became real, and CISOs and lawyers suddenly decided, you know what, maybe we want to sign this just yet. We want to go back and start all over again and really take a deep dive. It's amazing when your signature is on here how real this becomes. And so this is why this is the most important part of this whole thing. Comments, questions, thoughts about that? I know I ran through that pretty quickly, but I want to make sure that you had an opportunity to ask questions. Okay. Let me share with you some of the lessons learned during this process. I don't think anything will be new, but I want to share it with you regardless. Yeah, yes, sir.
So, when Europeans, EU people come over here,
Yes,
I mean, they go through immigration, right?
yes,
So we take all that data.
yes.
Does the government also here has to be GDPR?
No, it doesn't. It's a great question because in principle, well, it's a great question. Because in theory, any government agency here in the US that processes personal data of EU data subjects has to be GDPR compliant. So yes, you are right in that context. I don't know how it applies to immigration when people are coming in for either they have a visa, don't have a visa, but they come in, they have their passport stamped, they have it entered, I'm sure, in a system. They've probably been scanned before they come in to make sure they're not on a bad guy list, etc. It's a great question. The short answer is I don't know the answer, but I will find out because it's something I should know. I've never gotten the question before, though. It's kind of interesting, so I would be happy to research it. Other questions, other comments? Okay. Let me share some lessons we learned. Again, none of these are going to be new to you, but I want to share what the corporate world has as a consequence of DPIAs. They don't understand the nature of personal data. As I said earlier, for every application that they found that processed personal data, they found two that they didn't know about. And they didn't know about it, one, because they had never done a data inventory, and two, when I briefed them on just what qualifies as personal data, they didn't really appreciate it until it became real in a DPIA, where now they had to really dig down and understand what qualifies as personal data, like online identifiers. Again, we didn't know where the personal data was in their information ecosystem. So we talked earlier about applications they didn't know about. They didn't know about things that were stored on certain servers or in certain file shares that had been forgotten. They just didn't know where anything was, because if someone leaves the organization, that knowledge goes out the door with them. And a lot of times there were orphan systems that we found that they didn't realize were there. Didn't know with whom data was being shared, and this may be the greatest sin of all, because if you don't know with whom it's being shared, it's hard to hold them accountable when something goes wrong on their end. So if a third party business partner had that data and they weren't clear who had it, because there was no inventory of who had what data, if something went wrong, we probably wouldn't have known about it until it appeared in the news, which is not the time you want to find out that your information system is not up to snuff. And really, it's not just an information system, it's your legal system, because there's no accountability for sharing that data with third parties. These organizations were not well prepared to legally share the data in the sense that they didn't have well-developed contractual processes. And in fact, in some organizations, the attorney that was quote-unquote in charge of privacy didn't have any view into the attorneys that were actually handling the contracts. And I thought that was shocking, because that was something that landed on my desk with regularity when I was at my defense contractor. People would always bring me contracts and say, hey, would you look at this? And the idea that you wouldn't know where all your contracts are that implicate personal data, I thought was very scary. Not well prepared to address a data breach. This was consistent in most of the organizations I worked with. They talked about how they were prepared, but when I asked them, well, if something happens tonight, who would you call? One client said they'd call me, which that's very kind of them, but that wasn't what I had in mind. And so I found that in almost every case, they were not well prepared. There were some that exceptions stood out. Banks, in particular, stood out fairly well, but most organizations did not fare well. And finally, they were not able to focus team efforts. This is something that really came out in GDPR, is that GDPR required almost every organization in a company to work together as a team because it crossed so many boundaries. Most organizations were not well suited to working in that kind of capacity. In many cases, people were working together that probably had never worked together before. And so they were just not well prepared to work as a team and focus their efforts to meet GDPR demands. And I think we're going to see GDPR fines and penalties and so forth as a result down the road. I've got about 2 more minutes, and I promise I won't keep you a minute over. Any comments or questions or anything that you want to share before I wrap things up? Yes, sir.
So just curious, I noticed like in one part of your plan that you were doing the data, right?
Mm-hmm.
It looks like it comes out by business process.
Yes.
And so just wondering if you find it, because oftentimes creating is certain capacities are done by system rather than by business process.
Mm-hmm.
So I know like the working that system records and CCPAs have to match up to that.
Sure.
So the boundaries of the system can have multiple processes as part of the process. So would you recommend kind of doing it based on a system-based approach or just process-based approach?
We did it on the former, on a system-based approach. You can make a great argument that it could be done the latter. Really, from the perspective of GDPR, we went for systems because it was easier for us to identify and easier for the client to identify. And so that's the model that we used. But you can easily make a case for the one you described, just because as long as it's finding the personal data, that's all that matters. And it may be easier to find it the way you're describing it rather than doing it system by system. But this is the first pass at a privacy inventory, data inventory that companies have done. I suspect we'll see the model change over time as a consequence. Other questions, other comments? I do have some resources for you, and this deck will be available to you afterwards. One more minute, and I will wrap things up here. I mentioned earlier the nature of data has expanded significantly, and so, of course, our abilities to respond to it as well. GDPR introduces this idea of rights and freedoms, and I really hope that we'll all take that to heart. I think that approach really adds, as I said earlier, a second opinion to how we conduct PIAs. And I think DPIAs tend to dig a level deeper than perhaps we've thought out previously, and as a consequence, I think they have a lot of value. There is a document that is called WP248, and this is something that you can Google and find. It's the Bible, if you will, for DPIAs for the EU. A lot of great information. I highly recommend it. I also recommend, obviously, the US documents as well, OMB documents. The Data Protection Commissioner of Ireland has a lot of good information, and I cited them simply because a lot of US companies are headquartered in Ireland when they conduct business in the EU. And so the Irish Data Protection Commissioner now has a very prestigious position vis-a-vis those companies. And then allegedly there's a new ISO standard for DPIAs. I haven't examined it, but it probably bears some review. And we are exactly at a quarter after. I promised I would not keep you guys. Please do fill out the evaluation that my colleague has handed out. I really would appreciate getting your honest opinion. And like I said, if you want, we'll do a drawing. Just put your contact information on there. We'll do a drawing, and I will be happy to brief your legal team on any data subject that they like on privacy. So please do that. And thank you very much for joining us today. It was great to see you all.